I'm going to share with you one possible argument alongside several other possible arguments that I might run if I eventually get sued for this parking charge notice that I told you about in my previous videos, which I will link in the description below. And this is something that's not yet been fully tested in court, and it cannot be held to be legal advice. It's just something that I'm going to do, which you might find quite interesting. In fact, it's something that someone else has picked up as well from Moz on Moz Models. So a nice little shout out here. Do go and subscribe to his channel. I've had a look and it brought me back to my boyhood days of building models. So do go and check out his channel. It's fantastic. Now, what I'm talking about in this video is derived from the Consumer Contracts Information Cancellation Additional Charges Regulations of 2013. In English, this means these are the regulations that are imported into any contract for consumers alongside the terms implied by the Consumer Rights Act of 2015. Now, anybody who is acting in the capacity of a consumer is somebody deemed to be acting wholly or mainly outside of their individual trade, business, craft, or profession. In terms of driving, this would obviously apply to you if you're driving your vehicle in a personal capacity and outside of your trade and business and so on. So this would probably exclude drivers driving business vehicles, unless, of course, it's on your own time and it's your own parking and it's nothing to do with the business, trade, craft, or profession. And just as a caveat, many companies do try to say, often through lawyers even, you must prove that you're a consumer, and that's not true. In fact, in the Consumer Rights Act, it says quite the reverse. It says that a consumer who says that they're acting in a consumer capacity is doing so, and the trader must prove otherwise. So if the trader wants to say that you're acting in the course of business, they must prove it, not you, as the otherwise would be consumer. And specifically, the bit I'm talking about from these regulations is this bit here, making information available to a consumer. So on the basis that you are a consumer, this is making available to you as a consumer before you enter a contract as a consumer. And for the purposes of this part, something is made available to a consumer only if the consumer can be reasonably expected to know how to access it. Now, this is important for parking, because on a sort of private car park, we're talking about private car parks here, because after all, if it is a penalty charge notice, that's something different. You're parking in the wrong place against the regulations and you might get fined for that. I'm talking about private parking, privately managed parking, which might give rise to a parking charge notice, which is a private alleged breach of contract between you, the parking company managing the car park on behalf of the landowner. Now, that is a contract. When you go onto the car park, there are signs that tell you where to park, how much to pay for parking, how long to park in the bays, etc. Or in my case, in my video, with a permit. I had a permit. In that case, it's a contract. You're entering a contract. However, as many people have pointed out before, there is a lot to entering this contract. Now, all things being equal, if everything were fine, let's say, everything was fair, everything was clear, then you are entering this contract by driving onto the car park and parking, paying your fee or displaying your permit or whatever it might be. You are entering that contract. But as a consumer, there are certain things that must apply to such things, such as making information available. Now, there are other regulations to do with private parking and this sort of thing, but this is certainly one thing that is yet to be fully tested in court, which could well be a valid argument. And I do know of people, including Moz here, who have had parking charge notices cancelled on this very ground. And it's certainly one argument that I would be running. So I thought I'd make a video about it to explain. Making information available. So you are only bound as a consumer to a contract if certain information is made available to you in certain situations, such as what many of you might know as a distance contract or an off-premises contract. Distance might be over the phone. Off-premises might be anywhere other than the trader's ordinary place of business. And so there are a couple of places within these regulations that deal with each of these. And one of them is under 10, Regulation 10, which is information to be provided before making an off-premises contract. That is, not the premises of the trader's main place of business. Before the consumer is bound by an off-premises contract, the trader must give the consumer information listed in Schedule 2. I'll come back to that in a moment, in a clear and comprehensible manner. And if the right to cancel exists, the cancellation form, etc. Moving to the next tab under 13, this is a distance contract. So let's say you're over the phone with these people and it's concluded over the phone. The same applies. Make available the information in Schedule 2. Moving to Schedule 2, this is the interesting part and relevant part here. Because the information referred to in 10 and 13 is subject to the note at the end of the schedule. The information to be provided in distance and off-premises contracts is as follows. Obviously, the main characteristics of the goods and the services, which will be parking as a service. Identity of the trader would be the name of the trading company that's managing the car park. But also, and here's an interesting point here, the geographical address at which the trader is established and where the trader's telephone number, fax, and etc., to enable the consumer to contact the trader quickly and communicate efficiently. Now, a geographical address must be a physical address. Now, the ordinary rules are that a PO box is not sufficient. It's not sufficient for banks as a sole address. It is not sufficient for many other types of business. A PO box is not a geographical address for the place of business of a trader. But many parking companies only use a PO box, including the one that I had a dispute with here, or have an ongoing appeal with here that I'm waiting for them to come back and respond. This company is nationwide. This company uses a PO box. It uses a PO box on their signage all over the place. And on the Contact Us page here, it has a PO box to contact them. No geographical address. So that does not meet the terms of the regulations. But going back, as the wording is very clear, before the consumer is bound by an off-premises contract, they must make this information, including a geographical address, available to the consumer, at which the trader is established. So it's got to be a proper address. So on your business websites and things like that, on your letters, I mean, many businesses, including ours, we use a PO box address, but we also use a geographical address. Now, if you don't want it to be, let's say you work from home and you don't want your home address, you can use another address. It's got to be a physical office address. You can have a registered address, maybe your accountant or something like that. You can use as a correspondence address, as an additional address, a PO box, which diverts anywhere you wish. But you need to have, for consumer contracts, a geographical address. That is deemed to be one of the minimum requirements, along with lots of other things. There's a whole list of things in this Schedule 2 here that need to be provided. The existence of any codes, the cost of returning goods, complaint handling policy, all these sorts of things. Most of which, for the point of it, are not going to be on a sign, on a car park sign. And certainly the one point among many that will be run, because if they do sue me, if they do dismiss the appeal and the independent appeals dismiss the appeal, and then eventually if they sue me, I will be telling you how I structure any defense to such a claim, each of the alternative arguments, because a lot of people don't realize this as well. You don't just have to use one argument to defend a claim. You can use many different arguments. You can say, and as we would say in court, if the court is not with me on that, then my alternative argument's this one, and my alternative argument's this one. It's further or alternatively. So you can use any one of a number of different defenses, but sometimes you'll use your best defense and not sort of cloud it with several other defenses. But in the case where it might just be one technicality, well, this is wrong, and this is wrong, and this is wrong, and this is wrong, and any one of those that are wrong ought to defend the claim successfully. I mean, the other way around, you might have a breach of contract for 7 reasons, and any one of those is a valid breach of contract. And therefore, you would plead all of them, and any one of them would be a satisfactory breach. But in this case here, one of the potential defenses is if they only use a PO box, then they have not complied with these regulations. It's a consumer contract, and it is not a geographical address. Therefore, as a consumer, you would not be bound by that contract in the first place. As I say, that is yet to be properly and fully and robustly tested in court. And it may even be something that ultimately goes all the way to the Supreme Court, just as in the Beavers and Parking Eye case, where there are arguments made that it was an unfair term, and the Supreme Court said, no, it's not unfair. There are arguments made that it was a penalty, and the Supreme Court said, no, it's not a penalty. It's just a fair administrative charge, and so on. Those arguments went on through the Supreme Court case with Beavers and Parking Eye in 2015. This is one such argument that may end up going that far. Perhaps even with me, but let's not get ahead of ourselves. This is one argument that I'm going to use among many others if they do actually decide to sue me, which, for what it's worth, I doubt, because my argument is very fair. The term on display, in simple terms, just means you can see it. It is displayed somewhere that is reasonable to see. You don't have to bend your neck. You don't have to walk around the vehicle. You don't have to squint and strain. It was absolutely plain as day, visible from the outside, from the point at which the parking attendant would have stood to put the thing on my windscreen in the first place. They would have seen the permit. So they would have seen the permit. It was on display. There's no breach of contract. So it shouldn't go any further. But I thought this was an interesting video to cover off with you. There are many other minute and technical angles that I might be looking at. So do hit the like button and subscribe and the notification bell if you haven't already, because if you're interested in these kind of things, especially with parking charge notices and how to fight them, how to deal with them, this is one such way that I will be doing so. But for many people that are confused as to whether or not you are a consumer in such situations, the Supreme Court already talks about these scenarios as being as a consumer, unless the narrow situation where you are driving for business, a business vehicle, and you are definitively within your trade, that might be different. But in these cases, clearly a consumer. Hope you found that interesting. Please do subscribe and catch you next time.